Good day, ladies and gentlemen. Welcome back to another What If video. In today's video, I will unpack the question whether a trade union can represent employees in an unfair dismissal dispute if the employees work in an industry that falls outside of the scope of the trade union's constitution. Now, as you are aware, unions have various rights, including the right to bargain with employers and the right to represent members at the CCMA and labour courts. Registered unions are required to have a constitution containing the scope of industries in which they operate in. Now, the right of a union to organize, in other words, to acquire organizational rights, such as access to the workplace, deduction, election of shop stewards, etc., was however in 2020 curtailed by the Constitutional Court when the court found that a union was restricted to organizing within the scope of its own constitution. Now, that matter is the lawful packaging matter, and the Constitutional Court held that the trade union cannot recruit members who fall outside the scope of its constitution and seek to exercise organizational rights in relation to those members. But can a trade union represent employees who are employed in a sector which falls outside the scope of a union's constitution in individual dispute proceedings as opposed to organizational rights dispute? Now, in the recent judgment of NUMSA and others versus AFCRI Animal Feeds, the Labour Appeal Court was called upon to determine this exact question. Now, let's unpack this case. In terms of background, the employees were dismissed by the employer after engaging in an unprotected strike at AFCRI's premises. The employees then referred an unfair dismissal dispute to the CCMA. Following an unsuccessful conciliation, the CCMA issued a certificate declaring the dispute unresolved. NUMSA and the employees, represented by their legal representative, then referred an unfair dismissal dispute to the Labour Court. Now, the court was tasked to consider various issues. However, of importance to this video was the issue of whether or not NUMSA was entitled to represent the employees, this despite the fact that the employees fell outside the scope of NUMSA's constitution, or at least the operations of the employer. In this case, the Constitution did not cover employees engaged in the production of animal feeds. So what did the Labour Court say? The Labour Court considered the lawful judgment that I referred to earlier, wherein the court found that a union may only refer or represent a dismissed employee if that union is registered and if the dismissed employee who is a party to the matter is a member of that union. The Labour Court, relying on the principle in lawful, confirmed that the employees in this matter, the AFCRI matter, fell beyond the scope of NUMSA's constitution, and therefore the employees' membership of NUMSA had been invalid and void from the outset. The Labour Court therefore found that NUMSA held no standing to represent the employees. NUMSA appealed to the Labour Appeal Court. Now, at the Labour Appeal Court, the judges disagreed with the Labour Court and reasoned that it's not the business of the employer to concern itself with the relationship between individual employees and the union, as the employees enjoy the right to choose their own representatives in unfair dismissal or unfair labour practice disputes. The Labour Appeal Court reasoned that NUMSA was a party to the proceedings in terms of Section 200, subsection 2 of the LRA, as the union purported to act on behalf of or in the interest of its members, and was therefore not acting in terms of Section 161 of the LRA. The Labour Appeal Court found that there is a distinction between individual employee rights and collective bargaining rights. In this case of individual employee rights, an individual has a right to choose a representative in unfair dismissal or unfair labour practice disputes, as I said. The court held that different considerations were present in unfair dismissal disputes compared to collective bargaining disputes. In collective bargaining, special industry knowledge is needed. However, in unfair dismissal disputes, one needed to consider fairness and the right of the employee to representation in individual dispute proceedings. The Labour Appeal Court held that the relationship between a trade union and its members is a voluntary and consensual one, aimed at the promotion of convenience and the preservation of rights. However, when a trade union acts outside of the scope of its constitution, the trade union is limited in the representation it can provide to the employee and will not be entitled to bargain collectively with the employer on behalf of that employee. However, it would be able to represent the employee in individual disputes, as this representation is aimed at providing effective access to justice and redress to the employee in accordance with our Constitution and labour legislation. The Labour Appeal Court accordingly upheld the appeal and found that NUMSA held the requisite standing to represent the employees in the dismissal dispute. So in conclusion, ladies and gentlemen, as it currently stands, this case entitles a trade union to represent an employee or any employee at the CCMA hearing that is not dealing with organizational rights, regardless of whether that employee is in fact entitled to be a member of that union. Now, rumor has it that this matter is on its way to the Constitutional Court, so we will have to wait and see if the Labour Appeal Court's decision gets overturned. However, I will keep you updated. Now, that then brings us to the end of this video. As always, thank you for watching. I will see you in 2 weeks' time. Bye-bye.